4 minutes. Two minutes. Start wrapping it up. Okay, time's up. Who finished in 7 minutes? Who finished in 8 minutes? Who finished in 9 minutes? Who finished in 10? Who is still not finished? Who is still not finished? Okay, so that means a lot more issue spotting practice, like a lot. Like there's no magic number. You know you've reached the magic number when you're like, I got it. I can't even look at this anymore. It's like nauseating to me because I just got it. That's how you know. That could be at 6 essays, 10, 12. There's no magic number. You have to get there, okay? So it's okay if you're not finished yet. That's okay. It just means you need more practice. And you'll get there because practice doesn't have to be perfect, but it does have to get you to issue spot this very big issue spotting essay within no more than 10 minutes because you have to write, right? You have to write and there's a lot of IRACS. So it's training. It's just working through it, and you will get there. All right, so I do want some participation as always. We're a little smaller class today. I don't know where everyone is. Hope everyone's okay. But for those that are here, who wants to take on, let's do one applicant, one student at a time for each call. So the email. Assume all appropriate objections were timely made. Should the court have admitted the email? We are in California Evidence Code. Where do we begin the email? Anyone want to take this on by show of hands? Not all at once, really. Come on. Yes, thank you, Arturo.
I could give it a try.
Okay,
I'm not very confident just to start, just because
that's okay.
there's a lot going on.
That's okay.
Relevance would be the first issue.
What type? What do we start
Logical
with?
relevance.
Okay. Are we going to hash out Prop 8?
This isn't a criminal case, so we're not, even though we're in California, it's a civil case and not a criminal, so we're not going to apply
Correct.
Prop 8.
Okay, so great. So this first item of evidence, we're going to give a really good rule, right? We're going to give the full rule for logical relevance. And is the email logically relevant?
It is. There's a lawsuit here, and it's logically relevant to show
What type of lawsuit?
For defamation.
Okay. And in California, the fact must also be in dispute.
Right.
Okay. So this item of evidence, the email is logically relevant.
Yes.
Yes, great. So full R, full R. Okay. Let's see. Okay, keep going.
Legal relevance.
All right. What's
Which
the
is
standard for legal relevance?
Probative value. You're gonna balance it against the unfair prejudice that it may have.
Is there a high degree of probative value of the email?
There is high probative value on the email itself. Yes.
What's the analysis?
Here the email has a high probative value because
Here there is a high probative value in the contents of the email because
it tends to show,
or in the allegations of the email, because it contributes to the essence of the defamation lawsuit.
Okay. Yes.
Leaving very little prejudicial effect. And you're done.
Okay.
That's it. So it doesn't need to be lengthy. You don't have time for that, but it does need to get to the meat and potatoes. Okay.
Okay.
All right. So we have our full R, A, C, and legal relevance is met. Okay. Where do we go from there?
Reliability, personal knowledge.
What threshold? It's not personal knowledge because we have a document.
Right. After that personal knowledge, I was going to do authentication.
Good. We don't
David,
have a lay witness on the stand, right? We have a document,
no lay
we have an
witness.
email.
And the email is authenticated because David obviously produced it.
Right.
And okay.
Well, Ed testified that he got it at work.
Okay. Okay.
Right?
Right.
So this would be a good exercise of an essay to map out the parties in like the right-hand margin of your essay. I know we're typing, but you know, we got to know who's introducing the evidence. So we have authentication met.
And then California's secondary evidence.
Why aren't you confident? You're doing so great.
Oh.
Yeah. Okay. So what do we need for secondary evidence?
It's if well, secondary evidence rule states that the document or writing has to be produced if we're producing the contents itself, right? So here we're bringing in the email because of the contents themselves.
But if you can't have the original, then what is required? A duplicate, right? And here we have a printout of the email or a photocopy of one. So does that suffice for the secondary evidence rule?
Yes.
Good. Wonderful. Okay, we're not done. Where do we go from here?
Hearsay.
Is this hearsay?
I went to hearsay because there's kind of like a notice that's going out there. It's a non-hearsay specifically.
Non-hearsay. Why is it non-hearsay as opposed to hearsay?
It's going out to other employees, just kind of sending like a notice out there that PEM was terminated.
Walk me through what hearsay is, please.
Okay, hearsay is an out-of-court statement made by a declarant offer for the truth of the matter asserted.
Okay, so who thinks it's hearsay and who thinks it's non-hearsay? Raise your hand if you think it's non-hearsay. Good. Why? Hunter, why?
I think because it's provided by what's her name? Sorry. It's provided by Pam and she has personal knowledge of it.
That's not why it's non-hearsay.
Okay.
Yes,
sorry.
Anthony, but good
I
try.
haven't even gotten there yet. I've been
That's okay.
reviewing, so.
Anthony,
Would it be because it's false? That it's not being used to assert the truth of the matter?
it's not being used to assert the truth of the matter. What is it coming in for?
A state of mind?
What's the big one?
Notice?
Arturo, what do you have?
Well, I have a business record.
But it's not hearsay.
I got it.
Okay, what is it?
It's opposing party statement, right?
It's independent legal significance is the threshold that it's coming in for. It's coming in to show that we have a defamatory statement that goes towards the cause of action because you need a defamatory statement. So it has independent legal significance that makes it non-hearsay, that makes it admissible. Now, hearsay is definitely something to go into as well in lieu of, because remember, when you're dealing with evidence, you're dealing with every possible threshold matter. So if the other side, has a strong argument for it potentially being hearsay, because there is, someone said there's no truth, but there is some form of truth that it in fact is what it purports to be, which is defamation, then we do have a hearsay issue. So we have to back ourselves up with potential double hearsay as well, right? Did anyone get double hearsay? No? Okay, let's look at the email, the facts. I'm pulling it up here. A week later, David circulated the following email to all the employees. I just thought you should know that Pam was fired, so she did it at work. Pam was fired because she is a thief. Sue caught her stealing money from the petty cash drawer after Pam's affair with Mike ended. So someone said business record. Who said business record?
I did.
Yes. So you were right. I just wanted to hash this part out first.
Okay.
So we have hearsay as a potential exception to hearsay of a business record. So what do you need to do with double hearsay pursuant to the approach? First level is what? The record, the business record. So the email itself. Does this meet the 4-part business record test?
Yes.
Was it kept in the ordinary course of business? So here's the thing. Whenever you see an email on an essay or a work document that happens at the office, that is a potential hearsay business record issue. That's how you know. Now you know. So if you didn't get it, it's okay, but now you know. So first level business record, but no, it was not kept in the ordinary course of business pursuant to prong 4, and therefore this level is not met. You know you need both levels. Second level, this is why we do practice. See, you've done so much evidence practice and now you're seeing something new. This is why I keep stressing, and it's like I'm beating that dead horse. You got to bump up the practice. Okay, second level is the statement within the email. Now, just because the first level is not met doesn't mean you don't look for other exceptions to the second level. You're not done. You have to be full circle. So someone I think said admission. Did someone say admission? I think Hunter, did you say admission? Someone said admission.
Yeah,
by
I said
party
opposing
opponent?
party statement.
Okay, correct. So if you ever have okay, and forget about even work. If you ever have, everyone write this down. If you ever have a document and there's a statement within the document, that is double hearsay. Okay. Admission by party opponent. Is it a statement being offered against David? Yes or no? Yes. So the second level is met, but the first one is not, and therefore double hearsay inadmissible. Not coming in. Could potentially come in as independent legal significance. Because remember, in evidence, you're just trying to argue any way to get it in. So you've got to be thorough. You've got to be as thorough as possible. Now, that doesn't mean that your scope goes like here, okay? And you're starting to bring in irrelevant issues. Okay. Great job, Arturo. You want to keep going? Want to go, keep going?
Oh, no, I think.
No, you're,
somebody-
you're like, no, no.
Thanks.
Anthony, take it away. Okay, Sue's testimony. What?
I
if-
actually have a question.
Oh, I thought you were going to participate, but then you're going to participate.
Sorry.
That's okay.
Uh,
But then you're going to take. I'll answer your question if you're going to participate. There's a condition here.
First,
I'm just kidding. I'm
yes.
just Okay. All right. So what's your
Um,
question?
For Prop 8, even though this is not a criminal case, since it says California Evidence Code, do you recommend bringing it up
No,
and just dismissing it?
No.
Okay,
waste of time.
got it.
And also may think the greater in that instance may think you don't really know when Prop 8 applies. You're never going to
Okay.
bring it up. Yeah, just to bring it up. But I understand why you would want to be thorough there. Okay, so we have Sue's testimony. What does Sue say here? She says, Sue testifies she had caught Pam stealing $300 from the petty cash drawer, and that when Sue confronted Pam and accused her of taking the money, Pam simply walked away. So who wants to take on Sue's testimony? We have, well, let's just all do it together. I'm just going to kind of abbreviate here. Okay, is it logically relevant? Yes. Is it legally relevant? Well, there's a prejudicial effect of calling her a thief, right? But the probative value outweighs that, right? Yes or no? Okay, someone tell me why. Scott, tell me why.
Because it goes to the truth of the statement,
Of what?
of the allegedly defamatory statement. It's a defamation claim. And so if she actually is a thief, then that would tend to defeat, her claim of defamation.
Right, and she's also saying it's false, right?
Right.
Yeah.
I mean, yeah.
Is arguing that it's false. So
Right.
there is a high, right. What jersey is behind you? We're a big football family over here. I don't know.
Oh, it's a hockey jersey.
Oh, hockey. Okay, fine. I'll let that
The
go.
hockey jersey.
Go
Yeah.
Chargers. Okay. I don't know if they're going to make it, but they're giving us a little hope. All right. So where do we go from here? Anthony. So it is legally relevant as well. Do we have a public policy consideration?
No,
Okay. Do we have a privilege?
no.
Oh, actually, back it up. I'm sorry. Look at me. What did I forget?
Liability.
Yeah. Okay. What's the threshold for liability?
I have personal knowledge.
Beautiful. So does she recall her communication with Pam in the facts? Does she have direct personal knowledge of her communication with Pam? Sue?
Yes.
Yes. So we have personal knowledge. Probably reliability is the biggest missed issue when it comes to items of evidence. All right. So again, is there a public policy? Is there a privilege? No, right? Is there character?
Yes.
Okay, great. So let's break this up into two parts. We have a statement, Pam stealing $300 of petty cash. So in California, character evidence is admissible if it is an issue. The general rule, of course, it's not admissible, but if there is an issue in the case as it is here, we have a defamation case, and therefore the issue of whether she stole is relevant, and is at issue, making this admissible character evidence. California, and I did this issue spot this morning. California evidence is admissible when character is a material issue in the case. We have a libel slander case. So therefore, we have what would otherwise be inadmissible, admissible character evidence. Okay, what about the other statement? Sue's statement that Pam walked away. So whenever you have two separate statements in one evidentiary question, you have to break it up. So that's why I'm giving you this practice. It's so good to set standards to be applied for other essays. Okay, is the statement that Pam walked away hearsay, character, impeachment, privilege?
It's hearsay.
Who said that?
Me, Arturo.
Good,
She adopted whatever was said to her.
right. So
Adopted what he said.
conduct,
Yeah, conduct.
right. She's asserting something. She wouldn't have walked away if she weren't guilty. Goes to the truth of the matter asserted. So we have hearsay, identify it as such. Is there an exception that applies or an exemption that applies?
Would it be admission of party opponent?
Beautiful. Good job, Mahak. And what would we expect to happen? Why is it an admission by party opponent? Let's take it a step further. It's an adoptive admission, right? By party opponent. Why? What would we expect to happen here?
Because a reasonable person wouldn't stay silent. They would
Right. They
maybe
would deny
repeat.
the statement. Exactly. So she's accused of stealing and she doesn't deny it. She adopts it. And therefore we have an exception. Is there a third part to Sue's testimony? Is there C? So she says, we talked about stealing the 300, walks away. Sue's statement accusing Pam of taking the money. I do have a little non-hearsay here. It's a small issue to show its effect on the listener, Pam. Small sub issue, one model had it, one didn't. I wouldn't worry too much if you didn't have it. Okay, 3A, I think that's where we're at now. 3A, David's testimony about what Pam said. Don't leave me. Oh, so sad. Come on, we have to have a little fun with this fact pattern. It's kind of fun. Don't leave me. All right, so where do we go? Is it logically relevant? What is it related to? Whether or not what? Someone else. Rebecca, come on, you know. What's it related to? Whether or not
Whether or
what?
not she had an affair.
Whether who had an affair.
Pam had an
With
affair with Mike.
Right. So we have it being logically relevant, the key subject of the defamation action, which is whether or not they were having an affair. Legal relevance. Same,
Yes.
right? Whether or not they were having an affair. Strong probative value. All right, we're in what threshold now? Rebecca, I kind of threw it on you. Are you okay with that?
Okay.
Okay.
So
Sorry.
then now
You're
we
doing
go
so
to
great. Okay.
so reliability,
Okay. And what
And-
threshold standard under reliability?
personal knowledge.
Let's look at the facts. Isn't there some type of other authentication going on? She says, overheard Pam and Mike yelling at each other. He recognized both of their voices. What is that? Recognize the voices. Arpy,
Authentication
of what?
of the voice.
Voice authentication is the threshold there. So we have to have authentication that David is familiar with Pam's voice to make this testimony, which it says he is. Now, and that's why that fact was there. So if you didn't see that, go back to that fact, and that should be clearer for you now. Where do we go now? Rebecca, you want to keep going? Do we have character, privilege, impeachment?
I said impeachment because it could be a prior inconsistent statement. No,
I don't see that. But good try. I don't see that. What is this? It's coming in to prove the truth of the matter asserted that they were having an affair. It's hearsay.
right. And then it's a party admission.
Okay. Admission by party opponent. Good. I love when I issue spot this before class, because then it makes me kind of feel like I'm back in school, which I do miss. By the way, you will miss being back in school. Once you start practicing, just wait. Right, Scott? Not easy peasy.
I'm disagreeing with you on that.
You're
I
disagreeing?
never want to go back to law school.
Okay, fine. Well, maybe not law school. I didn't say law school. I said just like when I see students in Starbucks and like they got their Starbucks and not a care. I'm not saying not a care in the world, but it's like, all day long. And I miss those days where it was just like in the cafe, studying and jamming to my music. Like, I guess maybe it's a youthful thing. I don't know. All right.
I'm with you on that. Yeah, I'm with you
Okay.
on that.
Thank you. So statement offered against a party. Yes, statement made by Pam being used against her. Admission by party opponent. Is it anything else? Please don't leave me. Yes, Hunter.
I had a then existing emotional condition.
There's something a little bit more accurate though.
Could it be excited utterance?
Spontaneous statement is what we call it in California, right? But yes, same meaning. So we have a statement made while under the stress or excitement of the event or condition. Please don't leave me. Conclusion, it's admissible under both exceptions. This essay is a doozy, is it not? Long. All right, 3B. David's testimony about what Mike said to Pam, our affair is over. Let's take it. Do you see how we never lose our threshold headings, right? We don't go see above, we don't get sloppy. This is what's going to keep you getting your points, just like that essay Feb 13 in crimes where we had multiple defendants with conspiracy, solicitation, right? Attempt. You always keep your headings. This is definitely a training skill that will maximize your points, and most applicants will not know how to approach this, okay? So, good job. All right, who wants to take this on? Is it logically relevant? Our affair is over. Is it related to Pam having an affair? Yes. It's a key part of the subject of the defamation action. Is it legally relevant? Yes. Quickly in and out here. You're not probably starting to run a little bit out of time looking at the clock. And by the way, when we're dividing the time into 2 minutes per IRAC, it's literally like eventually what you'll do, and I'm going to have you do this on the simulated, When it goes to 12:41, like you're telling yourself by 12:43, I'm out of, like, I'm done with this IRAC. Like, you have no choice. I don't care if you have the best argument, you have no choice. You've got to conclude and get out. All right. So we do have to start kind of spinning and turning, not spinning, but turning the wheels on timing, right? Because it's such a crucial component to the test. All right. What is our threshold reliability standard? Our affair is over. Same thing, no? Everyone see voice authentication? David is presumably, we said, familiar with Mike's voice. Is this privileged? Any type of privilege? No. Is it character? No. Is it impeachment? Yes or no? Mac, did you have impeachment? No?
I didn't.
Okay, good. So what do you have there? Putting a few of you on the spot today. But you're doing great.
I went straight to hearsay after
Beautiful, that's
reliability.
correct. That's right. So why is it hearsay? Pretty much redundant to the above argument, the previous item, right? Goes to show whether or not there was an affair and what type of exceptions are we dealing with here?
I don't know if this is correct, but I put present state of mind.
I think that could apply. There's a few of them here, by the way. So sometimes you'll have one, sometimes you'll have three, sometimes you'll have four, usually no more than that. 3 to 4 is like the max exception you'll deal with. So what's the rule for present state of mind? What does it go towards here? What part of the state of mind? The intent, right? David's
Yeah.
intent to do what?
To leave Pam and to
To
end
end
the affair.
the affair, right? Okay, so that's definitely a exception that applies. Anything else? Is it a dying declaration? Are you going to put that down? I would put it down just to negate it. No proof that he was dying when he made it. What else? There's 2 more. There's a big one. Hunter.
Would like the statement against interest or the statement of personal family
Declaration
interest
against interest.
or history?
Okay, what is the rule for that in California? You have to have an unavailable declarant against what interest in California? It's a little different than the federal rule. Penal, financial, or social interest. This is a really hot exception. It gets tested almost every evidence essay. Make sure you know how to identify this. He's unavailable, he died. And what's it against? It's against his social interest. Our affair is over. So it's admissible under declaration against interest. There's one more. The models had it. It's an excited utterance. Minor. Oh, I spelled that wrong. Sorry. These nails need to be cut. When they're breaking. All right. Why does this not suffice? Why does this not suffice? What fact tells us it's not an excited utterance? Someone look at the facts, please, and tell me.
That it ends in a period instead of an exclamation point.
Nope.
In a measurable tone, in a measured
In
tone.
measured tone, right? So do you see, you should start seeing why they're giving you these forms of words, these combinations of words, right? They go towards, like if you see that in your writing and you spotted excited utterance, you're like, that was the correct issue to spot, because that's why they gave me that fact. All right. Conclusion, it's admissible as a declaration against interest and present state of mind. Is there any other parts of the statements? What about you need to get on with your life? Did anyone have that? You need to get on with your life? It's minor. Anyone have that part? No? Okay, let's look at the facts and see what clue is there. So if you have a question asking you about a person's testimony, you have to cover the whole testimony. So if every time, for instance, let's look at the last paragraph. He testified he overheard Pam and Mike yelling at each other in Mike's office a few weeks before Pam left. He recognized both of their voices and that he heard Pam cry, "Please don't leave me," in a measured tone. "Our affair is over. You need to get on with your life." So technically, I think, "Please don't leave me. Our affair is over. You need to get on with your life" is one fact, one testimony, excuse me. The fact that there's like a dash there, I think that's why one model made it a separate heading. Either or, I think, could have maximized your points. There's a small little issue of effect on the listener, Pam, right? A small little issue. This would not be a make or break it. But if you saw it, extra points. So what do we see from this essay? We see, ooh, we can have an essay with a lot of IRACS. We see that we can't spend too much time on any one issue. We see repetition of the threshold issues of evidence that we cannot miss. And just like a lot of times you'll see repeaters have answers where they're skipping relevance altogether. And the first heading is hearsay, right? So we definitely never want to do that. To maximize your points, if you follow this approach, you follow the checklist, and you do a lot of practice. I mean, I love this essay because it tests so many different twists and turns. We didn't see impeachment. We didn't see a privilege. So we had a lot of hearsay with this, but you definitely can get essays that are heavier in one area versus the other. If you have a pure evidence essay, you're always going to have a hearsay issue. It's going to be there somewhere. So make sure also, I think the majority of you did not see that double hearsay. That is crucial for this essay as well. And moving forward, anytime you have a document, anytime, and there's a statement within that document, you are going into double hearsay. Okay, everyone clear on that? So hopefully you took that away from this exercise. What did you think? Was this a hard essay? Hard, medium? Thumbs up if it was hard. I think it's like between medium and hard. I think the facts are pretty straightforward, but the breaking up of the conversations, now you know to do that, right? That's a big one too. And going into the approach over and over again, you see how, this is a beautiful approach because it really can be applied so down the row, right? You're not going like contracts where it's like more, right? It's like those, remember when you went to islands? Remember, is there still an islands around? I don't know. When I was a kid, we used to go to that a lot. You know, it's funny. I was reading on Facebook, someone said like, you know, those memes that go around like, what's your favorite movie, right? And then one said, well, where did your parents take you for your birthday when you were younger? And I'm like, Sizzler, like that was our place. But now it's like, you know, a kid turns 5 and in LA, they're going to Mastros. I don't know. I mean, it's like, what's wrong with these old school places? I do miss those, but I think they're still in islands. But remember the Connect the Dog game? You guys remember playing that at the restaurant as kids? No? I was the only one that played that. Come on, you know what I mean? The Connect. You made the dinosaur, you made the fish, right? Okay, thank you. So that's like what an approach is. And sometimes the dots are like, yeah, I got this. And then other times it's like you messed the whole thing up. So give yourself some credit, even when you mess up, even when you miss things, to just make it a learning curve. Speaking to applicants and starting the process of tutoring was so exciting yesterday. And I love starting that process because that's really where we see what's going on. And I can see the state of mind for some applicants. One in particular that I tutored yesterday that is not here today, but I wouldn't say it anyways. But my point is really struggling, right? With just fears of the previous test. And I mentioned this the first class, and I kind of want to leave it here today because I think as we get closer into mid-January, the fears, especially if you've never, if you've taken the test before, excuse me, if you're a repeater of the test, start coming in. Like who can be honest that they are feeling like that a little bit, where it's like, oh my gosh, I didn't pass last time. That's going to happen again. So I really want you to work through that in the next coming weeks. Because by the way, and this again is not a fear statement, it's more just reality. We're going to be bumping it up. We're going to be doing non-MBE and then going into MBE again. So the state of mind has to be stronger than it's been. It's now time to even get more powerful with really rejecting the negative talk and having a positive mindset through this process, okay? For the most part, I will say this class in all is really impressing me. I'm really enjoying, and I don't say that every bar, and I'm not saying everyone doesn't deserve that statement. I'm just saying you guys are really working hard. I'm not having to like be kind of a drill sergeant as much as I tend to be at times. So good job getting your work in. For those watching later, good job too. We're going to conclude. I want you to make sure you add in hearsay, add in those questions if you missed it on the schedule. I've given you an extension on constitutional law writing. Constitutional law writing should be creative. It's like real property. You're not going to get a racehorse, maybe 10, maybe 11 IRACS. That is a place where you have to shine. I have seen, and this is not my recommendation, I'll say this again next class, I have seen essays in con law with 80s from repeaters by just kind of BSing the analysis. Now, of course, that's not the goal, right? I want you to write eloquent, good arguments, but there's not a lot to say with con law. Like you spot your issue and you'll see you've got to have the ability to analyze scrutiny levels. You have to think like the court would, and you have to understand, of course, the issues and know how to spot them. So don't forget your justiciability issues at the beginning: standing, state action, ripeness, mootness, right? Those do cost a lot of points if you miss them and they're at issue. So it's really hard, I think, sometimes to go from such a big subject like evidence right into con law. So maybe take a few hour break right now and let your mind kind of simmer, have some lunch, and then get back to it, okay? Homework. I want everyone next week on, I thought I had the schedule here, let's see. Okay, by the 21st, so by Saturday the 21st, I want everyone to spend a few hours going through their notes from the beginning, starting with criminal law, and making sure they have a clear key for yourself on areas, approaches, multiple choice categories that you still need to improve in. Performance test there should be a section on that. Can just be in your notebook, but you should have, or you can write stickies. Who's using stickies? I love these. Okay, they don't make enough of them. I feel bad throwing so many out. Hopefully they're getting recycled, but in any event, my son got me into that, like recycling. Oh, he's so like that. But anyhow, my point is, well, he like showed me this video of like where it goes. It's really not good. You should really be into that. But I'm not going to talk about that today. I want you to make sure you have a good key of where you still need to work. So spend some time. We can't just keep going. We have to stop and regroup. Okay. So make it a regroup session with yourself where you go, oh, that homicide approach, I really need to go back to that. Right. That contracts essay, I got to do more UCC. Have a key for yourself, because when we get to practice next week and we start re-review by the 21st, 22nd, you're going to need to have a targeted re-review. You're not going to be able to review everything again. It's impossible. You won't have time. It's got to be your weak spots. Your weak spots. Okay. Yes, Hunter.
So I started the re-review a little early, as per.
That's only because I recommended it though.
Yeah.
Yeah.
So I was just wondering, how much time should we allocate daily for re-review?
So I'm not going to go into that right now just because the class is not starting it yet.
Okay,
but I will go into it, but just everyone else, because for you, it's a little bit different.
yeah,
I'm having
sorry
you on
about
a
that.
little bit. It's okay. It's not a big deal. Just send me an email. I'll let you know. Okay?
Oh.
All right. Any other questions before we conclude? No? So everyone's gonna get in their con law essays. Did everybody outline the PT from last week? Okay, if you haven't gotten to that, really make sure you do the outline of the performance test. I am gonna be covering some PT lecture next week. I'll be going over what I see on your initial performance test, just kind of overall. For the most part, everyone did pretty well on State v. Martin. What I saw the biggest mess up for some applicants is in the task, it broke up a 2-part test per evidentiary item that the lawyer wanted to get in. I think it was a temporal relationship and a substantial similarity. Was that the 2-pronged test? You had to analyze that for every item of evidence. The task told you to do that. So if you missed that, that's because you didn't read the task carefully enough, which is not following instructions, which can really cost you points, okay, and lead to a lower score. So keep doing the practice. Don't neglect your PT outlining, and I will see you next week. I will see a lot of you this week. By the way, for those coming into the office, this is not my office, I'll be at the office, for tomorrow and Friday, we'll send parking info via Skype prep later today, okay? Bye, everyone. Good luck. Keep it going. Keep it moving. Have a good one. Bye-bye.